We're live. All right, people, how is everybody doing? This one was down to the wire, making it on time and not being more than a second late. Mic check 1, 2. Is this thing on? If that dog barks, I may have to text my wife to put him somewhere where we won't hear him. Okay, here's what happened. I didn't get to exercise before this stream because as I was coming back from somewhere, getting ready to go exercise, for goodness sake, I saw a car stopped in the middle of the street, and I thought someone had gotten hit by a car. And then I pull over, and there's 4 elderly people like circling the car, and there's a little baby squirrel terrified underneath the car in the middle of the street. And so I got there, and I was like, someone's going to get killed over a baby squirrel that's stranded in the street. So I got a bag out of the car, and I got the squirrel into the bag, and then I took it home, thinking that we were going to nurse the baby squirrel back to health. But ultimately, I went and put it back in a safe location by the area where it was, under a bush. Hopefully the mother finds it. And I figure, at the very least, cynically, if the mother doesn't find it, it'll feed something. That's just the way nature works. Let me just ask my wife if someone can get that dog. Can someone get the dog to stop barking, period? Question mark. Okay, whatever. That didn't work. Okay, so, no, the squirrel, whoever said rest in peace, baby squirrel, the squirrel looked like it was going to be fine. It was terrified. I kept it in the bag for 10 minutes to get its breath. I really wanted to keep it. I was prepared to get rid of that guinea pig to make room. But we have a small jungle in the house. I mean, at this point, it's a small zoo that we have in the house. I was just like walking the dogs yesterday, one after the other, and then we took the guinea pig to the park, and we've got these tadpoles, which are developing at an amazing rate. They have like big eyeballs now, and they're doing great. Okay, so that's what happened. So I didn't get my exercise in today, and I feel a little jittery because I had the double espresso at 3:30 and then didn't get to exercise. My whole balance is off. Okay, on that note, how is everybody doing? Let's see here. I don't want to fall behind in the super chats before I even have the chance to give the warning. Let's just see what we can do. If the city gets fired, okay. See, this is what I mean. Sometimes I don't read the chats before they come up, and I don't want to. If I bring up a chat, it does not mean I endorse the message or humor. Although I appreciate the humor that is intended to go into that. Viva, please pronounce Roanoke. Roanoke. I think I did it wrong the other day, guys. And what do we got here? Just give Winston a toilet roll. Speaking of Winston and toilets. Oh, and now the super chats. Before I get to even give the warning, let's see what I can do here. Is there a spot on Locals where I can share the serious issues with the Peas case? Not sure what that is. Some of these things may fly over the heads of those who are not medical pros. Okay. Anywhere. I mean, just post to Locals. I think that's the way it goes. And then the posts rise to the top, much in a Reddit or what's another, thumbs up driven based system. Would you and Barnes explain the possibility of the AFL, American First Legal? Well, when he gets here, okay. So first of all, we've got a menu tonight, and it's a big one, and we're going to hopefully keep the subjects to less than 50 minutes per subject, so we can deal with more than a few. Let's see here. Hello. But on the menu, let me just go ahead and... Did he eat? Yes, he did. Maybe not. I don't know if the dog ate. I'm losing my mind, people. Okay, let's get the menus. The menu of the evening of subject matter that we shall discuss is going to be... I've lost Robert's... We had a list here somewhere. Chauvin verdict. Chauvin appeal, obviously. Rittenhouse donor being doxxed. It's an interesting case. And there's interesting case. I don't know what's going on in the world anymore. DC becoming a state. Very interesting as well. Vaccine passports. O'Keefe versus Twitter. The kneeling soccer lawsuit. Kirsten Henning getting booted by Chugger from the soccer team. DeSantis riot bill and the subsequent lawsuit, which I read but didn't do a video on. Daily Mail versus Google, and the DC Muhammad Anwar kids getting a plea deal. which I made a video on today. And there's certain stories that are they're just sad, and they're just sad, tragic, disgusting, depressing, and no amount of punishment is going to make anything different, and no amount of forgiveness is going to make anything different. It's just a question of what, if anything, can be brought out of it that is not just pure destruction. So let's see. Oh yeah, sorry. Standard warnings, standard caveats. I may not get to all the super chats. I will not get to all the super chats. If you're going to be miffed if I don't bring it up like mechanical fluff and say, do you think YouTube is a little more tender-handed with you and Barnes' fellow lawyers? Good question. I don't know. I definitely don't think I push the envelope like other people push it. And that's not to say anyone justifies having their channel demonetized. Rebel Media got fully demonetized, suspended. They know they push the envelope, but that doesn't justify what happens to them. Salty Cracker, oh geez Louise, can't remember his name now. Lotus Eaters, pushing the limits, but nothing explains the censorship, the sanctions, the seemingly unidirectional, from an ideological perspective, sanctions. Tried poutine homemade for the first time because random family vids keep popping up. As an American, it wasn't bad. It's delicious. Okay, all that to say, I may not get to all the super chats. If you're going to be miffed that I don't get to yours, don't give a super chat. It will make me feel guilty, and I don't like feeling guilty. Second thing, YouTube takes 30% of super chats. If anyone has a moral qualm with that, as I can understand you might, there are other ways to support the channel. VivaBarnesLaw.locals.com. What else is there? No legal advice. I will accidentally bring up comments that I didn't mean to bring up. When I bring up a comment, it is not an endorsement of the comment. Try to keep things civil and respectful in the comment chatty section thingy. As much as it's the internet, we should still have respect for each other and our beliefs and our diverging beliefs. In Chauvin, was there a difference between the felony murder statute and the felony murder jury instructions, given with regards to the intent requirement? If so, is them appealable? Okay, we're going to get to it because it's amazing. And I see Robert here looking dapper. He's struck a pose. Robert, how goes it?
Good.
Okay, before we even get into anything, what's behind you for the books of the week?
Sure. So it's The Myth of Moral Justice is that one, which is about how the legal system often does not match what the expectations of the legal system are in terms of the moral aspects of a case. There's a good goes in detail about what Learned Hand said about jury selection and the problems with the myth of blank slate jurors. So it's apropos for our current case. And then Win Your Case by Jerry Spence, which is all about different methods of persuasion that you can use in a lot of areas of life, independent of and separate from the courtroom itself.
All right, excellent. Now, Alyosha says, poutine is one of the 7 deadly sins, and awesome. It is. Now, Robert, we've done 3 different discussions on the subject, so some people might be hearing this for the 3rd time or the 4th. Some people might be hearing this for the 3rd time at the very least, because we were on with... who were we on with, Robert? Gruler on Friday. I did a bit with Matt Christensen and Blondie, which is going to be in their live stream tonight, where I discussed this. So it feels like the 3rd or multiple time that we've been talking about it, but it is going to be the first for our audience. So, let's get into the verdict itself. Everyone has been up to speed on the trial. We have been covering this in sufficient detail every Sunday. Robert Gruler's been covering it every day. 3.5-week trial. They go into deliberation the day after Maxine Waters issues what can only be described as an implicit, if not an explicit, threat of, what was the word she used? Confrontation, in the event that there's not, the maximum conviction. She wanted first-degree murder, which wasn't even on the table, suggesting that even if there was a conviction on the felony murder, that it would still be, deserving of more confrontation in the streets. They deliberate, sequestered for 10 hours, come back with guilty across the board on all 3 charges. I know what you think about it. I think everyone out there knows what you think about it, but let's hear it. What do you think about it?
So, I think it reflects the problems with having a trial in that particular venue. So it's also revelatory, hopefully, to some lawyers, and probably revelatory in ways good and bad for a large part of the audience and people watching, which is that it sort of destabilized believability and trust and confidence in the jury system itself. But this is the reality of how jurors are. About, more often than not, jurors come in, have already made up their mind whether they themselves are conscious of that or cognizant of it by the time they sit down. They come in with presumptions and assumptions that are going to filter and frame the evidence in a particular way. And if this had been a conscientious jury, then to have a quick jury verdict should always be acquittals, if they're in fact a conscientious jury, because the burden of proof is on the government. That's the highest burden of proof known to man, beyond a reasonable doubt. There are multiple elements you have to get through to convict, but there's only one element you have to get to acquit. So it makes sense. Like the OJ jury came back quickly because if you believe not guilty on some aspect, then that's it. And here you could say not guilty because of reasonable force. You could say not guilty because of causation. You could say not guilty because of intent. You could reach any one of those three and say, okay, that resolves it. To get to a guilty verdict this quickly is, again, revelatory about the weaknesses in the jury system and the way humans make decisions in general.
This is what I said, from the beginning, I guess, once it came down. 10-hour deliberation. I mean, it's not even one day. 10 hours is sort of almost a lofty way of describing the length that they deliberated. It was out on Monday. The conviction was announced Tuesday at 5:00. There was virtually seemingly no consideration, or at the very least no appearance of consideration, that went into the conviction, because I know a lot of people think it was darn obvious. You had it on video, et cetera, et cetera. Bear in mind that the three charges themselves, it almost took the judge more time to read the criteria for a conviction on the three charges than they took in deliberation. These were like multi-pronged levels of evidence in order to get to the convictions, especially on the felony murder. So when I heard that they were announcing it the next day, I was like, oh, maybe they were actually convinced that the excessive force element had not been met, which therefore allowed all three charges to drop, because maybe they were convinced by Nelson's argument that Chauvin could have used more force, even by the expert's own testimony, that the scene was sufficiently unsafe or felt unsafe, not just for Chauvin, who pulled the pepper spray when someone came around from behind him, UFC fighter, giving him the eye in front of him. Even the EMS said they didn't feel comfortable administering first aid there and had to move. So maybe they just felt that all of the conduct was not excessive force, or at the very least justified police force, to get to an acquittal on all three. And instead, conviction on all three, no questions to the judge, no asking to read back evidence, no inquiries as to certain considerations. I mean, I've never practiced criminal law. I've never had a jury trial, but I mean, how does that happen? Like, typically when there's deliberations on a high profile case, on a very intricate case, you get the jury coming in with questions asking to reread the evidence? No?
Well, I mean, if they're a conscientious jury, yes. Now, the reality is in America that it shows you how biased jurors tend to be, that a quick jury is almost always a guilty verdict, and a not guilty jury is almost always takes their time. So it gives you a sense of how. That's why I always tell people that get up about beyond reasonable doubt and so forth. Practical reality is most jurors don't really apply beyond a reasonable doubt. If they think you're guilty by 51%, they're not going to say, well, that really doesn't meet the. No, they're going to convict. So that's the unfortunate reality of it. We just got to witness it on display. And as we talked about before the trial started, this case was as much the American justice system being on trial as Derek Chauvin being on trial. And unfortunately, the justice system badly failed in terms of the court of public opinion in certain aspects of those people who followed it, and even around the world. It's sort of, and I'm sure with police officers across the board, because what they have a right to ask questions to the judge about any aspects of law or evidence. They have the right to have evidence read back to them. They have the right to ask for evidence to be produced to them if there's some questions or doubt. And you'll see this with not guilty verdicts. Not guilty verdicts, you'll often see, as Zimmerman as an example, that's a comparable kind of case. Multiple jury questions, multiple requests for evidence. They usually take at least a week. I mean, here you had a 3-week trial with very complex factual evidence on causation, very complex factual evidence on reasonable force, to some degree complex evidence about intent. You had 25 minutes of video, most of which they had not seen until the trial, some of which they hadn't even seen during the trial. They never even apparently looked at all of it, ever, other than what the bits that were shown by the defense in close. And so it's a sign of a jury that made up their mind before they sat down, and that you can have questions as to, and it appears that they lost this case in the court of public opinion, that they because of the media gaslighting a very simplistic, singular narrative that failed to include exculpatory evidence or context, including expert context for reasonable force, context as to causation, context as to simply what led up to that last 9 minutes, the 16 minutes beforehand. All of that didn't matter because they had, for a year, this jury pool had been saturated in the government's prosecutorial press narrative. And what it is, it turns out you can't overcome that narrative. And they don't even pay attention to it. And here we got some revelatory insights. What we talked about before the trial was if it's a bad jury, it'd be a quick jury. And unfortunately, that's what came to fruition. But the alternate juror interviews.
Well, that was the next question. Someone asked in the super chat, will that alternate juror's testimony change anything, impact anything? I guess in order, just to back it up a little bit, the alternate juror's testimony was that she felt pressure to render a decision a certain way. It wasn't just pressure. It was they felt intimidated or pressured or threatened in order to render a certain way because of what would ensue if they rendered it a certain way. And I mean, it goes without saying what that was. I guess the first question is chances of appeal, grounds of appeal, and whether or not this juror's, the alternate juror's, what's the word I'm looking for? Interview is relevant, will change anything, or is a non-issue?
Well, two things that stood out. One is it's what I call memento memory, based on the movie Memento, which is fantastic.
Classic.
But it shows you how powerful motivated reasoning works when you read her interviews. And she appears to be completely unaware of almost everything the defense presented in the case. I mean, she said that, that she didn't understand. She said the defense set out to prove stuff that they never proved. They actually proved more than they set out to prove. So in the opening statement, she said that she didn't understand why Floyd died over a $20 bill. How can you sit through 3 weeks of trial and still think that media story is true?
Well, let me just say, I brought this up. Why does anyone care what the alternate juror thinks? They weren't sitting on the jury. That's not correct. The alternate juror heard the evidence.
Oh, yeah. She sat through the entire jury. So she only was an alternate in terms of voting. But that everything else, she could have easily been one of the voting jurors. The fact that she wasn't a voting juror doesn't change the fact that she was one of the jurors who sat through the jury trial, and you're getting a glimpse into what all the other jurors thought by what she talked about and disclosed and discussed. And so you get the memento memory, the motivated reasoning. And this is what I often tell people: trials are theater. Most lawyers spend tons of time on the trial. They think, if I just win this cross-examination, or I just get this evidence in, or I set this up for closing, that will help me win. That's simply not how human beings tend to operate. 70 to 80% of the time, they've made up their mind after opening statement. A lot of times, over half the time, before they've sat down, frankly. So and we saw clear evidence of that in what she discusses. So that aspect is not necessarily an appeal issue, the sense that, this is the reality of jurors, and it's a reminder to all criminal defense lawyers out there that it is critically important. Jury selection is by far the most important thing you will do. And yet to this day, 90% of lawyers don't even employ a jury selection assistant in the jury selection process. Most of them rely on cheap stereotypes and limited information and limited intel. It also appears that they did not do, I'm guessing, meaningful focus groups, mock trials, and polling. This is true for 90% plus of defense lawyers. It's just ludicrous. It's borderline malpractice these days to not understand this is how the human brain works, and to get out of the mythology of how jurors make up their mind. We don't have blank slate human beings. That's a myth. It's a dangerous myth, a precarious myth that can harm both justice and for your client and for the country as a whole and the justice system. So I think, I encourage people to listen to her commentary, and you'll see what I'm talking about clearly revealed. Didn't know what the defense evidence was, still thought the core gaslit media narrative from the beginning was true. But the revelatory part for appeal, or for the other 3 cop defendants, which somehow the media has forgot about, are facing trial in August. And this is why, President Biden talking about this, his fraudulency the second, Kamala Harris talking about this, the governor talking about this, the mayor talking about this, about Chauvin. They're going to all be on trial for the same thing in a few months. How in the world can that trial take place in Minneapolis after all of this, where the president of the United States has effectively announced them guilty by announcing Chauvin guilty? So under these circumstances, that they should at least get their trial moved. But hopefully they'll also learn you need to do polling and survey evidence. You need to show the difference. You need to bring in psychological experts who can attest to the way people work under bias and prejudice and pressure. Because her most revelatory point on that side of the aisle was her admission that maybe I'll now call it the Greg Gutfeld admission. Gutfeld got into some controversy.
For anybody who doesn't know what Greg Gutfeld said, now Crowder gave him a hard time, but Gutfeld basically said on the Fox 5 or whatever the Friends are, that he was glad that Chauvin got convicted, even if he didn't think he was necessarily guilty. He said he was glad he got convicted, even if he were not guilty on all the charges, even though he thought he was guilty, because it spared rioting. And he was saying, I was in a neighborhood, my neighborhood got looted. I'm glad he got convicted because it spared for the looting. I think he's guilty, but his statement was, I'm glad he got convicted, even if he were not guilty, although I think he was guilty, because it spared looting. I mean, he tried to back his way out of it. I think he might have misspoken in a sense, but taken flack for it, but he might have said the soft part out loud.
I think he was just being honest, and that's what he said. He said, look, I'm just being honest, and I think it was good that he was honest. I don't have a problem with it. I know Crowder took some shots at him, but I thought that he shouldn't have shots taken at him. He's saying what you can guarantee those jurors thought, and what the alternate juror admitted she thought, which is that, she didn't want more riots to occur. She didn't want more looting to occur. She didn't want more problems to occurring. There was rioting occurring during the trial. To ask human beings to make a decision of, hey, do what is right, really dig into the evidence, really consider it conscientiously, really try to figure out what the jury instructions are, ask questions where there's clarity, have evidence read back to you, but do so at the risk of your community, do so at the risk to yourself, is maybe asking an unreasonable thing. And I think that that's what that juror sort of communicated. And this was, in my view, the most significant effect of the Chauvin verdict was it was a mob. It was mob justice, and it was media gaslit justice, and that's a very dangerous thing for the justice system in general. And so I think that's why paying attention to this case is significant beyond Derek Chauvin, who I'm not a particular admirer of.
No, I mean, we know what we've said of Chauvin. We know what we believe of Chauvin. That being said, we have probably more thoroughly than 99.9% of the people out there followed the actual trial and the evidence and came to determinations that might defy our own initial reaction and our own personal beliefs. The issue is the jury was never sequestered during this entire trial. They know what's going on. They know there's literally riots, not outside the courthouse because it's a militarized zone, but there's riots in the city. They are not sequestered when Maxine Waters says, if we don't get a conviction on all three counts, we got to get more confrontational. They are probably not unaware of the fact that a severed pig's head was left on the steps of the former house of one of the experts. And yeah, I mean, it's asking people to do the difficult thing. And I brought up a couple of chats versus asking them to do the impossible. One super chat said, I like to think I would have been the stubborn one who said, stick to my beliefs. This is what I believe. Someone else in the chat responded, it's not just you, it's family, friends, job, everything. It's a virtual impossibility. And you deliberate for 10 hours after a 3.5-week trial, which had like you said, medical questions that were complex, causation questions that were complex, excessive force questions that were complex, legal questions that were complex. The three charges: felony murder, a second-degree felony murder, third-degree depraved mind murder, and manslaughter, that came with a slew of legal criteria and conditions in order to be proven in the judge's directions. 10 hours. It almost, in hindsight, now looks like the decision was deliberately made quickly to send a message. I mean, you can think he's guilty, but there, at the very least, I would say it cynically, feign consideration. Spend a few days doing it. Don't come back the next day and say guilty across the board on all of these complex issues when everyone knows the immense threats and pressure, direct and indirect, that they are under. So, if Chauvin is looking at an appeal, I suspect he is. What are going to be the grounds of the appeal? I guess in order of strength.
I think that Chauvin has an exceptionally strong appeal. Now, I think that for Chauvin personally, there's not much hope because he faces tax charges that are ongoing, state and federal. He also for not filing tax returns for many years, which probably means deeper corruption problems, as I've suggested before. And now the U.S. Department of Justice is investigating him for prior incidents. So they may, they're just going to keep coming after him forever. So and I don't have a problem with that if it turns out he's guilty of prior incidents. As I said from the get-go, his long history raised red flags for me. But so to me, the significance of this appeal isn't about Derek Chauvin or about George Floyd. This is about the justice system. And what happened here was a travesty of justice. This was mob rule, this was rule of the mob, not rule of law. And that's not something we can, either because they were part of the mob or because they were afraid of the mob. And frankly, as we talked about the closing arguments discussion, this was the government's explicit pitch. Just remember the video you saw before you came in here and listen to the mob and do what they need. I mean, that was basically what they said, if you really paid attention to what the thematic structure of that closing argument was. So that's why it's deeply disturbing. There's a bunch of, would-be commentators that are highlighting the difficulty of filing criminal appeals, the difficulty of winning criminal appeals. In general, Popat is doing his usual spiel. Proves how useless he is. I mean, the inability of these people to make independent commentary because they suffer from variations of Trump derangement syndrome shows you should never hire or trust those people as your lawyer because they're incapable of being independent of thought, and they're too politically blinded to actually care for the constitutional rights they pretend they care for. But in that context, he's got exceptional grounds for appeal. Now, in general, yes, appeals are tough. And this is one of my criticisms of our criminal justice process, as we got to witness in this case. Years ago, political scientists got together and said, we should have some objective metrics to measure totalitarian governments. They wanted a scientific tool to say, see, these countries are totalitarian and these countries are not. One of the things they came up with was they noted that totalitarian countries, a hallmark of them, is very high conviction rates in their criminal justice process. Well, folks, the United States has a higher rate than most totalitarian governments do. So that should tell you how bad our criminal justice system operates. The simple risk of human error is too high for us to have conviction rates in the high 80s and low 90s. And it is true that most appeals go nowhere. The Court of Appeals look for excuses to rubber stamp what the government did. Our courts are continuously weak. They're filled with the Amy Coney Barretts of the world, who, as long as they do the right thing, get fat checks like a $2 million check for a book that ain't going to sell 1 million copies. So there's nothing but that, a payoff.
The government can buy them and distribute them to new arrivals, which
Kamala Harris,
like Kamala Harris, in the greatest form. What is that? That's not embezzlement. What would that be qualified as? For anyone who doesn't know, the government is buying Kamala Harris's book to give to new arriving immigrants, I believe, in the States. And Kamala Harris says she didn't know about it. But wonderful that tax dollars are at work to buy. Conflict of interest is probably the word I was looking for. Tax dollars to buy the book of the current sitting vice president. Oh, go ahead, Simon, because I have no words for it. But
yeah, it's one of the easiest money laundering techniques out there. It's how you can bribe people with these, and speaking fees, board fees, and book fees. And I'll probably be doing a future hush hush on or deep state episode on the way some of these book publishers operate, some of the people they've paid off. And if you track some of the history of some of these publishers, they might have some interesting ancestral heritage to a certain part of the world, to a certain famous party. So that'll be on at Viva barneslaw.locals.com, where you can find all that information. So, but outside of that context, there are arguments that are much stronger than others. And here the court of public opinion, particularly in the legal world, can make an influence on their understanding of the Chauvin trial being a disgrace of a trial and being very damning of the American criminal justice process and confidence in its independence and integrity and impartiality, which is the constitutional requirement for a jury. First issue, unique issue he has. Usually appeals are tough also, because all you're appealing is some small evidentiary ruling, something minor, something that's not legal, something that's really technical, something that requires they dig into the weeds. Those are very difficult, and that's where most of them are. If you look at the appeals that win, they tend to be on questions of law, questions of law about the jury instructions, questions of law about venue, questions of law about jury selection, questions of law about big pieces of evidence. He has all of those. So first, there's the question of the felony murder statute itself.
Just stopping there. That's a pure question of law, correct? I mean, there's going to be pure question of law on the felony murder. Can it be interpreted to include as the underlying felony the assault itself? Because I know someone just said, explain to me how does a man kill him? How does someone kill a man 3 times? There are 3 separate and distinct charges. The sentencing will be cumulative and not consecutive. So 3 technically different charges. The first of which is the felony murder, and the question of law on appeal, which they reserved, before the trial even got started. Can the underlying felony itself be the assault that leads to the death, as opposed to a distinct felony? So,
well, I think people's point that they should have been making a decision between the charges and not just saying yes, yes, yes. Raise questions about the jury's deliberation method and about the law itself. So it's like, okay, which did he do? Did he intend to kill him? Did he not intend to, but was reckless? Was he being reckless in general? Was he only being reckless towards him? Quite clearly, they didn't care about any of those questions by the timing of their deliberations. And it does raise questions about convicting on everything in the manner that it was done, because theoretically you're deciding between the charges. It's either this or this or this, not this and this and this, because it can't be manslaughter and reckless murder and felony murder. But the way in which these jury instructions and law were created are part of the problem. But the other part of the problem is what took place in terms of the law itself. So the first big question will be, the felony murder statute has never had this set of issues presented before the Court of Appeals and the Minnesota Supreme Court, which is if you simply, according to the government, you don't even have to prove someone intended to cause bodily harm. That you can be convicted of felony murder if someone dies and you didn't even intend to cause them bodily harm. Seems like a problem.
No, and this is why, Nate Brody was saying this from the beginning, and nobody was really disagreeing that it's strict liability if you commit a felony, which leads to a death, regardless of what it is. And even if it is the underlying assault itself, you get felony murder in Minnesota because they don't have the merger doctrine.
They don't have the merger doctrine, but they've never addressed it in this context before. So they haven't had to really deal with it in this context. And the second part of it is they have actually tried to limit the scope of felony murder by saying there has to be a judicial finding and by implication a jury finding that the crime itself has an inherent serious risk to human life, and that in the circumstances present, it had a serious risk to human life. And so the first question is whether the felony murder, that this is a provision of law that doesn't make sense. Most every other state has rejected it. The common law tradition has rejected it. So now they have to confront it face up. Are they going to allow any murder to be felony murder because it contradicts other Minnesota court doctrines and the long history of felony murder? The second is whether or not they made a mistake in the jury instruction on felony murder, both on intentionality and on the question of what the Minnesota Supreme Court said is you have to make a determination that in the facts of the case, there was a serious risk to human life by the nature of the underlying felony. This was requested as an element in the jury instructions. The judge did not give it. That is also a major question on intent issues. And again, these are places where the government could have been more careful, because this jury would have convicted no matter what was in those instructions, given the nature of it. They decided to gamble they cared more about getting a verdict, even if it gets overturned down the road. Their obsession was verdict now, worry about the appeal tomorrow. So those are the two questions on felony murder, whether the law itself can apply to these set of circumstances, number one, and number two, whether or not whether that jury instruction should have been changed in the way the defense requested.
Okay, now here, hypothetically, the law itself is deemed to be, interpreted against the standard rules of interpretation. So the felony murder charge, let's just say they drop it entirely. He's still convicted on the 3rd degree depraved mind and manslaughter. Does he get sentenced on those, or does it go back for an entire new trial if they decide to drop the top charge on which he was convicted?
Most likely it gets remanded solely for sentencing. It's only if the felony murder component of the case had an impact on the jury that could have impacted those other two verdicts, which is not likely to be determined here. The next question he will have will be, or the next appeal issue he'll have, is whether or not reckless murder applies, because the plain language of the statute and Minnesota Supreme Court law going back over a century said that 3rd degree reckless murder could only apply when you're doing something dangerous to multiple people, not to a single person. And so the Court of Appeals decided to ignore that. And the question will be whether the Minnesota Supreme Court revisits it and actually enforces their rules. There's a very strong legal argument there. Again, the trial court judge himself said it didn't apply initially. It's only the Court of Appeals saying, no, let's railroad this guy that said otherwise. Their opinion was frankly ludicrous. I don't think he'll get relief at the Minnesota Court of Appeals. It's too political. I don't think they're interested in the law. I think they're more interested in politics in this case. But the Minnesota Supreme Court really kind of should take it up. Otherwise, they set a precarious precedent for other cases. Then the third issue he has is on the legal issues, also jury instructions related to those, both intent and causation. So beyond the second-degree murder instruction, there's also a third-degree murder instruction issue in question. There's also intent and causation areas that were frankly not very clear. And so those issues have to be resolved, because one of the arguments of the defense is that the way causation should be interpreted is that you have to be a substantial factor means there can't be, means that the other factors could not have actually caused the death. And that was their interpretation is it has to be the case that but for the knee, he doesn't die, that that even without the knee, he does die, and they have to prove without a reasonable doubt, beyond a reasonable doubt otherwise. And so that causation question, and to some degree an intent related question, will also go up on that issue as well, because again, some of the intent instructions were pretty vague and had some contradictory provisions. That's just those issues. Those are all exceptional issues where what would most likely happen in that context is if they could remand for an entirely new trial, or they could remand for sentencing on just manslaughter, which has a top, which would radically change his sentencing exposure. The third level of issues that he has relates to the venue and sequestration. And that, again, is a very unique set of issues to have. You have the choice not to move the trial was unusual. In other words, in comparable cases involving high-profile political cases where the police officer, where it's a police officer-involved incident, they have almost always moved the case. They moved the Rodney King case. They moved the Diallo case. They usually move other cases like that. And so consequently, the fact that they didn't move it will be a major issue. And this will be highlighted by what the same judge does with these other three cops. Now, they have stronger arguments, and hopefully they'll accumulate better evidence for moving the case. But what does he do? If he moves that trial, it makes it look bad that he didn't move Chauvin. If he doesn't move that trial, it's even more egregious to fail to move it. So that will be that we'll see his decision on that will give us a clue about where the higher courts may go on it. But then the sequestration. Sorry.
No, sorry. It's on the same. Okay, so finish with the sequestration, and then I'll ask the question on the what happens.
Sure. So there's two questions that are present. Should they have been sequestered throughout the trial? And in the same capacity, should they have been instructed not to have any access to the media or social media throughout the trial? The judge chose not to. And then during the trial, they were bombarded with all kinds of negative coverage about Chauvin. The Minneapolis press talked about it being the most press-saturated coverage ever. The judge admitted this, that it was the most press-saturated case, not only that he had ever been involved in, but that he had ever witnessed, period. And then on top of that, that was compounded by the fact that during trial, riots occur related to another police shooting where Chauvin is mentioned as part of that. Floyd is mentioned as part of that. And they clearly were witnessing that and seeing that. So that made the failure to sequester a bigger problem. Of course, they were also, $27 million settlement was announced during jury selection.
There's so many facts that are unique and call it, say, egregious, but just exceptional facts in this case. That the ongoing riots, Congress making congressional members making statements, the disclosure of a record-breaking settlement on the eve of the trial. One question: if the trial were moved, would it be the new judge or a new would it be the same judge or a new judge assigned?
There's multiple ways that can happen. He can move it to transfer it to a different judge. He can continue to be the judge, but simply have a different jury pool from a different community, and he even travel to that community. So that can be done multiple different ways. There's a lot of flexibility the judge has, and there was always risk that you lose the judge, but in this case, you're much better with a better jury pool than keeping the judge. So and then after that, there's the failure to sequester or even voir dire the jury about the riots that were occurring, or about Congresswoman Waters' statements, or about other politicians' statements. And we don't know whether they also heard the president's statements and other people because they decided to talk before they returned their verdict. So the sequestration issue will be a major issue. Usually in a case like this, the jury is sequestered. At a minimum, they're ordered not to look at social media. And that was not done. And he knew this was a problem because so many of the jurors had heard about the settlement. And so if he's saying, well, I told him not to look at anything, but he already voir dired him when they were told not to look at anything, and they admitted they'd heard about the settlement. So if they'd heard about that, how is it they didn't hear about everything else, including riots and congressmen demanding a certain verdict? So we haven't had facts this bad since the Sam Shepard case, which was the basis of the TV show The Fugitive, and then later the movie The Fugitive, where Snipes played in the sequel U.S. Marshals, which led to a favorable relationship with the Marshals, by the way. It's a fascinating little historical coincidence. But that the U.S. Supreme Court recognized venue problems from media coverage. That's counterbalanced by the Supreme Court's rather preposterous interpretation in the Enron case that said it was fine to do a jury in Houston when that was just not practicable. But these facts are worse than the Enron case, and they're much more akin to the facts in the Sam Shepard case. Plus, it's not just venue as an issue. He could have also expanded the jury pool. He chose not to. He could have also sequestered at multiple times, chose not to. He also could have voir dired them about sequestration. He chose not to. And given the alternate juror saying she was bothered by the riots that were ongoing, that shows that he made a mistake in the process.
Okay, so I mean, like, then what would be the outcome? Let's just say that the judge appeals says there was no fair trial, retrial in a different venue with a broader jury pool, or do they just say, is it possible to say he'll never get a fair trial given what's been done?
No, I mean, they'll say that they can always get one. I mean, what Learned Hand said years ago in that book was sometimes you can't get a fair trial, so you have to just get stuck with the jury that you can get. Mm-hmm. That's always been the solution. They don't refuse to hold a trial, even if they think every juror everywhere would be biased, because that was the reality in the case Learned Hand was dealing with, because it was the trial of communists at the peak of the Cold War. And clearly they couldn't get a fair jury really anywhere. But in this case, they would transfer it most likely to another venue, and I think he could get a much fairer and more impartial jury outside of the Minneapolis area. Now, it'll be harder now because of the publicity about conviction to do that. And what it probably means is you have to go to send out 5,000 juror questionnaires and find the people that aren't tuned into the case. And so or didn't tune into it much, or still willing to be impartial. But at least what you would remove, what was not true anywhere else in outside of Minneapolis. In Minneapolis, they were fearful for their own community and their own well-being. That's not going to be true in Duluth. That's not going to be true in the Fargo area, the Fargo media market of western northern Minnesota. So that they're not going to be worried about Antifa coming to Fargo town. So, and I'm referencing Fargo, the movie and the TV show. I mean, those are tough folks. They're not going to be worried about that nearly to the degree someone living right through it, driving through it on a daily basis would be. But that's not all. The other solution, other appeal issues he has, some big ones, is the failure to allow him to put up the drug dealer and make the drug dealer take the fifth in front of the jury. That's a major issue because that was a potential additional culprit that redefined the case. And it's a pure question of law whether he was right about that or not. And then the other one is in the rebuttal, the prosecution committed multiple acts of prosecutorial misconduct. So under existing Minnesota Supreme Court precedent, so if they're going to enforce that, the remedy has not been a jury instruction. The remedy is supposed to be mistrial. So those issues. So he has unusually strong evidentiary issues, prosecutorial misconduct issues, venue issues, jury sequestration issues, jury instruction issues, and legal issues about whether he could even be guilty of the crimes as charged.
Okay, so we'll see we'll see. How long does it take to file the appeal? If there's going to be one, will we know within a week or a month?
Oh, well, he's definitely going to appeal. He has appeal as of right to the Court of Appeals, so they'll have to hear it. But that might take a year and a half. Okay. And then he goes to Minnesota Supreme Court. Now, they don't have to take it. They should if they're conscientious, but we'll see. Then it could go up to the U.S. Supreme Court because of the constitutional issues about venue. That's a constitutional right that's implicated. The felony murder definition may be constitutional, but the bigger one is the venue issue would be the one that the Supreme Court might listen to, and the sequestration issue, because that's, again, constitutional issues. And then after that, he has habeas rights, and he can file that with the federal district court. That goes up to the Federal Court of Appeals. They both have to hear it. So at some point, the Minnesota Court of Appeals and potentially a federal district court and the Eighth Circuit Court of Appeals will be hearing the legal matters concerning this case. And the Minnesota Supreme Court and the U.S. Supreme Court may also get involved. And so we'll see. We'll see if they. I think the great fear is not that he doesn't have strong legal merits for his appeal. The great fear is that the case is so hot and so political that the kind of cowardly courts we have these days will take the same kind of action they've taken in the lockdown context, which is to find a desk to hide under. So time will tell whether they do what's right. Because, again, it's the justice system itself and the American justice system that's really on trial here.
Okay. Now people are voting, and I think I missed what they're voting about. One last question before we move on. Can you briefly explain the merger doctrine? Because I know that I will destroy it if I try to explain it.
Sure. So what is felony murder is supposed to be you go out and commit a really dangerous felony, and in the process of it, somebody dies. And they want to tag. I've never been in favor of felony murder, period. My view is I don't think felony murder should exist. But when felony murder started in the English common law, it was limited to very, very few cases because generally there weren't many felonies. We've dramatically expanded the number of charges that can be felonies. And so the way the courts have dealt with that, while still keeping the felony murder rule, and again, in Minnesota, they recognize all they did was codify in law, the common law doctrine. And so was to make sure that it could not apply to just any felony. So that's why, for example, in Minnesota, they've said if you kill someone in the middle of a sexual assault, you cannot be charged with felony murder. If you kill someone in a drive-by shooting, you cannot be convicted in felony murder. And that comes from various decisions they've made over time. If someone dies during a drug deal, you can't be charged with felony murder. That's what makes it ridiculous that this charge somehow you could be. And that's why they really like the interpretation that felony murder has been clearly interpreted to be anything. That's not in the Minnesota case law. That's just in the Minnesota case law's failure to address these problems in an anticipatory manner. The way most courts have resolved this is they've said you can't have the felony murder can't be the murder itself. It has to be a different, separate felony, and it cannot merge into the murder. In other words, if it's the same felony, then it's not felony murder, period. The context in which it first came up in Minnesota was unique. And the reason why they rejected the merger rule is it wasn't presented the way I'm talking about. It was presented as this kind of assault should never be considered felony murder because of the merger rule. And that's why they rejected it way back 30 years ago. There was not meaningful thought given to it. So that's why the Minnesota courts have never really thought through the implications. There's no decision in the Minnesota that says you can charge any murder as felony murder, but that's how it was applied in the Chauvin case. And that's why it presents that question. Most courts have come up with a solution of simply saying the only way to really solve this is to adopt the merger rule. If we adopt the merger rule, we don't have to deal with this. Minnesota has adopted other rules that say you have to charge you can only be sentenced to the least lowest level of sentence if the elements are the same. They've said that you have to have this special risk to human life inherent in the crime and as applied to the facts. But those weren't even applied here. So either they're going to reinforce those old rules to say felony murder didn't apply here, or adopt the merger rule, which is the way almost every other court has in the country.
Okay, and that makes sense, and that's just to avoid that every manslaughter becomes felony murder if the underlying felony itself was the act or was the assault.
Well, you even have to have a higher level of intent, according to the government's argument and closing argument. You have to have a higher level of intent for the lowest level of manslaughter than you do for felony murder.
Yeah, and we've mentioned that. That's the absurdity. Now, other people's argument is going to be, yes, it's the absurdity, but it's the law. We'll see if it gets interpreted accordingly.
It really can't be that, though, because you're interpreting a statute. And under the one canon of statutory construction is that you can never interpret the law to create an absurd consequence. So I get people are saying, hey, look, the existing case law allows for this to happen, but that's only because they haven't addressed this question head on. Because otherwise you're saying the legislature intended an absurd result, and that violates the biggest canon of statutory construction that exists.
I just want everyone to appreciate how beautiful that term is, canon of statutory construction, for the most boring concept ever of interpreting the law. Okay, well, that's it. Let's move on because we've done we've thoroughly gone through this. I don't think you'll find any better analysis and coverage of this trial than here. Robert Gruler, Nate Brody, Uncivil Law, a bunch of the other guys, but here in particular. We'll see where it goes, and we'll be on it whenever there's developments. Bringing it into the next hot subject of a trial that's coming up, Kyle Rittenhouse. The news in that case, I guess it's not really about the trial itself. It's about what's going on around the trial, freedom of speech, freedom of thought, freedom of association. a police officer donated to Kyle Rittenhouse's defense fund. I forget the name of the charity, but donated.
I think it was Give, Send, Go through a Christian. This was an earlier fundraising effort. People thought that that current Rittenhouse fundraising, which for those who are interested, you can go to vivabarneslaw.locals.com. There's a pinned comment towards the top that gives you the link to donate anything you want to support Kyle. That fundraising has not been doxxed or hacked at all. So this was an earlier donation.
Yeah, we're getting ahead of ourselves because what ends up happening, the news is, admittedly, it's a little sensationalist because they're missing some facts or they're omitting some facts for their own convenience. Cop gets fired for having donated to the Kyle Rittenhouse Fund $25. And he, with a note that says something along the lines of, keep your head up. We think you did nothing wrong. Something along those lines, paraphrasing. He gets fired. Now, the articles reporting on this discreetly mention once it was an anonymous donation and then don't go on any further. Then you get, then they go to the police force saying it's against policy for us to do things like this through official accounts, through official email addresses. Sorry. The impression I had reading this until I picked up on the word anonymous, until you and others explained it to me, I thought he had done it publicly through his account, through his official office, and made the statement through his official account, much like that soldier who criticized Tucker Carlson from an official account in his uniform. That's what I thought it was. It turns out that small little word when they said anonymous and then moved on, it was anonymous, and he did it through his official police account, but anonymously. His comment was anonymous, and the only reason it became known publicly was there was a hack, and the info of the people who donated anonymously were disclosed. And from there, from that hack, from that disclosure of the identity of the people who made an anonymous donation and comment, the police force says it's against their policy, and there's an administrative investigation leading to his firing. So, I mean, I don't even know where do we start with this? Let's assume, just for the sake of it, he had made the donation publicly through his official account with a comment under his official title. Would the firing make a little more sense?
I still don't think it would. I mean, and this is a reflection. It's not a coincidence that this is happening, because as soon as the Chauvin verdict occurred, you had people on social media saying, Kyle Rittenhouse, you're next. So, that they want to repeat and replicate and use as a template what happened in the Chauvin trial. Media, gaslight the media, gaslight the country, gaslight the jury pool. In the Rittenhouse case, the prosecutor has repeatedly lied and libeled Rittenhouse. There are other people that are doing it on a daily basis. I have a long list of people that will be knocking on their door after the trial is over, but who just lie and libel repeatedly and routinely. Ben Crump apparently got in on the act as well. I mean, you'd think, with how much money he's made from his race grifting, race baiting ways, maybe he'd learn, just take your cash and shut up about cases you know nothing about, but he can't help himself. No,
it's a question of power. It's a question of relevance, influence, which in some sense is already worth more than the money that he already has in the bank.
Oh yes. He wants to, this is a guy who lied about, if Ben Crump's involved in the case, odds are he's lying about what happened. That's just reality. He's a disgrace to the civil rights bar, in my view, and he undermines civil rights in this country by his repeated lying in cases and lining his own pockets based on those lies. But as it goes to Rittenhouse, he's going to be giving some of that money back if he keeps yipping and lying about the kid. So
I'm bringing this up, victim blaming. I presume you mean about the hypothetical if he donated through his official account. Look, Robert, there are, when you're a public officer, maybe there's policy on certain things you can say publicly in the name of your office, much in the same way people went after that military guy who in uniform criticized Tucker Carlson. People said it's a military attack on the press. So the base question, if it had been publicly official through his account, could it be justified? And then getting into the reality, if it wasn't public and it was only made public through a hack and then they take this action, does he have any recourse against them? Start with the first question.
It would depend. It would be a closer call if he had done this publicly in the name of his office, but he didn't. So it would still be an issue, but maybe not quite the same scope of an issue. I mean, Andrew McCabe was pretty public in supporting his wife's candidacy, and he was at one point the director of the FBI, and the degree to which he disassociated those two is in doubt. But here, this is someone who gave anonymously. He did nothing publicly. The only mistake he made for himself was that his official email account was hackable but that's not the definition of public activity or that could be prohibited or precluded under the rules. So that's part one. So part two is it's clear-cut First Amendment violation at this point. You have a very politically correct Norfolk Police Department that are pursuing that set of sort of path. And this has been established for a long time. There were some cops who participated in a very politically problematic parade in New York in the early 2000s. They were fired. They filed suit and they won because the government cannot fire people for their speech outside of particularly outside of their duties.
And that, I mean, it seems so obvious because when you find out he only used his official email address as the info address through which to make the donation. There was no public statement in the name of the police force on their behalf using their image or his position. It was hacked, and they take this hacked information to then effectively further expose and further publicize the statement, making it more public than it would have otherwise been had they not done this, and then fire him. And this is now a state actor taking reprisals against an individual for First Amendment issues. Their defense is going to be, well, he used our official email address for the confirmation of donation. Does it fly, and does he sue? I mean,
I'm sure he will. I mean, right now he has administrative appeals rights, but he should sue. I know there's a fundraising effort for him as well. But the people can't go around firing people for their political speech. Definitely not if you're a government employer. Sometimes private employers can, depending on which state you're in, but government employers sure can't. And so my view is that he has a very strong claim that it's a patent violation of the First Amendment, that he should win and prevail.
All right. Anything more on that particular case in the chat?
The people that are doing the hacking and the doxing and taking credit for it indirectly. One, where's the FBI? The FBI is still chasing down people that took selfies at the Capitol. Mm-hmm. Look at what they did to Julian Assange for exposing government misconduct. Why is the FBI nowhere to be found in this high-profile public hack? And to the degree to which the Guardian and some other publications may have been complicit in the hack, because it's not all that clear how distant they were from it. I think a lot of these people are maybe looking at future legal action. So whoever the hackers are and the groups associated with them can look forward to future suits because they're coming.
Something we didn't talk about was the investigation into Chauvin's expert.
One expert it didn't turn out to be his home, but they thought it was a pig's head with blood put on his house. And the other expert is now under state investigation for everything he ever did. This is an embarrassment to the justice system. This is retaliatory investigations, retaliatory prosecutions, retaliatory actions by private and public participants meant to intimidate people. I mean, they've done it to lawyers. They're doing it to everyone else. I mean, it's part of a path of not allowing experts or witnesses or lawyers represent someone in so that we can have a fair trial. And it should be embarrassing, but the media's and many of the legal left is celebrating it.
Especially since at least one of his cases, his conclusion was exactly on the other side of what his professional opinion was in this case. But it's the weaponizing of everything. It's politics ruining everything. It's egregious. You go after the lawyers for who they represent and try to get them disbarred, and now you go after the experts for testifying after 17 years of what otherwise seems to be irreproachable practice. It is it's nuts. It's nuts. I asked last week, please review Paul's truths. Paul, I think they mean your truths, Robert. Okay, so the police officer will see, I suspect, and I don't hope that there should be a lawsuit, but there should be a lawsuit, and we'll cover it if and when. But now let's go from one First Amendment violation to another. Do we do the soccer Kirsten Henning and
sure.
Virginia Tech? So I did
Same
a video
state, by the way. Realize we have a cop in Virginia fired for political reasons. Last week we discussed a medical student kicked out for political reasons. And now we have a female college player who couldn't play on her soccer team for political reasons.
So
the state of Virginia needs some help. Governor Blackface needs to pay more attention.
Well, it's confession through projection. Everybody's racist, and everybody who's accusing others of racism seem to have the ugliest history, from our own PM to Norfolk. For anybody who doesn't know the facts of the case, I did a video on it the other day. Female soccer player, Kirsten Henning, apparently a good soccer player. So I sort of skipped over a portion of the lawsuit where Her numbers were there. She was playing a lot. They were playing her because she was good. For whatever the reason, this is life on campus now. The women's soccer team decides that they need to get pro-social justice. And I say this without judgment to social justice. It's just that when you're on a soccer team, you don't expect politics to become an element of what you are compelled to do on a team. But they decide to go social justice. They decide to actively decide how they're going to support BLM, et cetera, et cetera. Kirsten doesn't... She doesn't necessarily support them, but she doesn't feel that this should be even part of the game. So when the whatever division or conference decides that they're going to make I don't want to say a unity prayer, a unity statement before their games that they all agree on, but don't run it by the players, and they all have to say this unity statement and then take a knee before the game. And Kirsten doesn't. She doesn't take a knee. She says in that game at the halftime, even though she was playing well and the game was going well, she gets berated by her coach. I forget his first name now, but his nickname is Chugger Adair. And when I see this guy looks like the guy from The Hangover, Step Brothers, the guy who always plays a jerks in movies, it's because he does. But bottom line, she says she gets berated by him during that game. Things go downhill from there. He berates her during practices. He doesn't play her anymore. He changes her position. She feels specifically targeted, and she feels it's because of her political views. She apparently overhears members of the administration of the team saying, "Oh, you probably have some racists on the team who think all lives matter." And then eventually it becomes so insufferable, she resigns from the team. Files a lawsuit, First Amendment lawsuit, basically saying state actor coach enacted reprisals against me because of my expression of my First Amendment rights, which is to not take a knee. And I mean, that's basically it. The lawsuit, I mean, I read the lawsuit. I know what I think. My only question is going to be, how do you what is the threshold to make the evidence of intentions? Because this is effectively only a question of intentions. It's going to be, how do you prove that whatever she experienced was as a direct result and a conscientious decision of the state actor to sanction her for her expression of her own political beliefs?
Well, one is I assume their defense will be that they did not constructively discharge her from the team, that she quit. And the question will be whether the harassing atmosphere caused her to get to that place where that was her only practicable alternative. But I think that otherwise it's a discovery case because, they can argue their motive had nothing to do with it, that they were just criticizing soccer, that had nothing to do with politics. The timing is coincidental. Other people's interpretations is just interpretive. But I think that, she has plenty of evidence that it's the other way, given the timing of the issue, given statements other people made. So I think that it just reflects the insanity of what's taking place. It's one thing to want to be political in your sport, which by itself is, in my view, a poor decision. But even if you're going to do so, and by the way, this is at the same time the International Olympics Committee considers it so offensive to sport to inject politics into it that they are banning people from taking the knee during the Olympics. They're like, or raising the fist. They're like, none of this. They're like, save your politics for politics, save sports for sports, and save sports from politics. And this is just an extreme example of it. But the fact that you have, Virginia Tech, located in a part of the state that's actually quite conservative, not the campus itself, gives you an idea of how bad it is. That a female soccer player who just doesn't want to use her sport to propagandize a political message she doesn't support or doesn't want to be a part of. She doesn't want to be. Her position was Black Lives Matter, but the group BLM is not in a group she agrees with because they believe in things like destroying the nuclear family, and a lot of people have problems with that. They're a bunch of grifters, BLM, bunch of grifters. I know that they never show up in any major case I've been involved with. I've had real cases of abuse, often racially tinged abuse, and BLM's nowhere to be found. They only want the bogus cases. They only want the Ben Crump race grifting, race baiting cases, so they can lie to the world about the situation and cause more division because that's their goal. Their goal is revolution. They say so overtly. Now, in the interim, they'd like to have 5 houses if you wouldn't mind helping them out.
Her explanation was those were for her family. That was her family money. There's nothing wrong with having money. She considers it to be her family money.
Nobody can account for a lot of the money. I mean, one of them just is under indictment for doing a bunch of funny stuff with the money. Most of the money has not flowed down to the community at large. It's just kind of vanished. And so there's a lot of questions about BLM. BLM is, a radical group, at least in theory, that promotes its own interest above the interest of the community they they claim to represent, and they have some really radical ideas
Well, so
that most people don't agree with.
That was what was specifically alleged in the lawsuit. She says, I believe in, I believe in social justice. I just don't believe in BLM tactics, which often involve violent riots and their self-proclaimed destruction of the nuclear family, which, goes against her views. What I find totally shocking in the lawsuit is the allegations of what goes on in the soccer teams. Like they discuss and sit there to say how they're going to promote social justice and require the players to wear, they were discussing a BLM armband or a BLM logo on their shirts, or to take the names on their shirts of victims of alleged police brutality, something along those lines. When you read about what's going on campus, just to read about it alone, setting aside what happens in this lawsuit, is eye-opening and shocking enough to people who don't already know that it's going on. But on a lawsuit basis, I don't, what do you need to prove? How do you go about succeeding on this claim? And then what would be the sanctions? She's asking in the lawsuit for First Amendment training for the coach. So, I mean, as far as that goes, is that a recourse that has ever been awarded in a lawsuit? Or
you have broad capabilities. I mean, it's why the Minneapolis police force is now under federal investigation, because they want to federalize the police force. This goes back to Obama, and it's because of how much discretionary remedy you have under the Civil Rights Act. So, I mean, remember, they bust kids and directed where kids could go to school under the same principle. So, yeah, they can do a broad range of things in terms of what they can put in declaratory relief, injunctive relief, reinstatement, and potentially a monetary relief, as the case may be. So I think she's got a good enough claim to get to discovery, and my guess is discovery will be very interesting. So if they were smart, they'd just, fire that coach, reinstate her, and move on. But who knows?
Okay, so we'll see where it goes. I mean, it goes to discovery. Is there going to be a motion to dismiss on the basis that not state actor, or didn't state a claim in law because whatever? I mean, do they go through with that, or do they just try to settle this?
They would have to say there was no way it could be a constructive termination, no way that these actions could be considered adverse environment. I think they'll have difficulty with that. So she should be able to get past the motion to dismiss into discovery, because she's alleged enough facts with reasonable inferences to it that this was a state act. Clearly, a coach is a state actor. People don't know. If you're a state coach, you're a state actor. The public school, university, doesn't matter.
And they allege the law in the lawsuit. These are things which, some allegations are allegations that need to be proven, but I sort of presume that they're not going to misrepresent the state of the law when they say a coach is a state actor. I mean, so operate on that basis. The question is going to be evidentiary as to whether or not, they're going to say maybe she quit because she was bad. We sidelined her because she wasn't performing. And then it's going to be sort of like that's the discussion with Colin Kaepernick as to what came first, the benching or the kneel.
And then it just becomes a fact question for discovery, because that's facts in controversy.
Okay. Well, so let's go from state actors to statehood. You're going to have to do this one for me, because I know what I've been reading, that DC wants to now formally become the 51st state, but that it's not even going to get past the Senate. So you got to explain the process to me, how you go about, how the government goes about recognizing a state for statehood. What are the constitutional issues in all of this? And what's the benefit of doing it? What are the constitutional issues, and what are the constitutional hurdles? Why do they say this is never going to succeed from the get-go?
So all you need to create a new state is to have the House and the Senate and the president sign it. But there are constitutional limits in certain contexts. And the big one in this context is the Constitution explicitly states the District of Columbia cannot become a state. So the way they try to get around this is they're going to say, well, we're going to pretend that the District of Columbia is only this tiny little portion of DC, and the rest of it's not really DC. It's just a new state we discovered. And that's their means of getting around it, which, by the way, would multiply. Not only would that would mean like about 100 people in a 3-block area would get 3 electoral votes. That's the consequence, because they had to amend the Constitution to even allow DC to have electoral votes because of the constitutional prohibition on DC having political representation. So the idea that they can circumvent the Constitution to create a state out of DC is just preposterous, and their means of doing so is just pretending that DC isn't really DC. It's only these 3 blocks right here, and everything else is a new free state. That clearly vitiates the constitutional purpose and principle behind the rule. So, and they're thinking because Alexandria used to be part of DC and they gave it to Virginia, but that was different. They weren't trying to create a new state out of what was part of DC. They were giving it to a pre-existing state. So that's totally different.
And I feel like a total idiot now because it might have just clicked. Is the entire political underpinning or the motivation of this to increase the electoral college and get electoral college votes from a state that is 90+% Democrat? And
to stack the Senate. They want 2 Senate seats. So that's their real goal. They want 2 new Senate seats from DC. And so so while they're busy thinking about how they could pack the court, they want to stack the Senate because they know that the Democrats have a disadvantage. Now, I'll say historically, by the way, this tends to backfire. In the 1950s, Democrats and Republicans got together and said, okay, Democrats said, we want Alaska because by golly, Alaska is going to be real Democratic. And Republicans said, well, we'll only let that happen if you give us Hawaii because everybody knows Hawaii is going to be real Republican. And you can see how that turned out over time. So sometimes these things don't always work the way they want to. Like if you actually gave DC statehood, what's stopping a whole bunch of conservatives from just deciding to move to DC? Because it's not a big, it's a small enough state you could politically flip the electoral votes and the states and the United States senators just by moving there. So it's not clear this would have the intended effect that they think it will, but it just won't pass constitutional muster. You can't create a new state out of anything that is the District of Columbia under the Constitution, and without amending it. And so that's why constitutionally the DC statehood is dead. Now maybe the courts will all take a walk and all pretend the Constitution doesn't mean what it says, but on an issue like this, I don't think so. I think they would even recognize that you can't do what they're trying to do. Now, it probably will be filibustered in the Senate anyway, but because the senator from West Virginia wants to be governor of West Virginia, that's part of why even Biden's barely disguised bribery attempts to hire his wife for things and stuff like that is not going to work because Manchin wants to be governor of West Virginia. He's got big eyes. And so he's going to stick with the filibuster. So likely we'll send him up from Arizona because she thinks he's the Democratic McCain and wants to carve out that image. But independent of that, the problem with DC statehood and the reason why it's never become a state is because they all know there's a huge constitutional problem with trying to pretend they can make it a state.
Okay, well, first things first, I think I just noticed Vosh is in the house, which is definitely a new political leaning in the chat or in the comment and watching. Welcome. Well, here's the question, though. So the process that they're going for right now to recognize the state of DC, it's what is it? A bill in Congress that they're going to bring to the Senate?
It's already passed the House, so now it's over to the Senate,
and it's going to get.
So, I don't think it will pass the Senate. If somehow it passed the Senate and the White House signed it, I do believe a court will say no, you can't do this. Yeah, this can only be done by amendment.
And so then, in order to do it by way of constitutional amendment, we've talked about that before. But remind me what the process would be to amend the Constitution to authorize DC to become a state.
They have to get it through the House and the Senate and then a bunch of states, which will never happen.
Okay.
So that's why DC statehood's always been a pipe dream. Puerto Rico is more practicable, but the problem is a lot of Puerto Ricans don't want to be a state. Not only that, their whole tax code is designed about them not being a state, which all that problem, they have huge headaches financially and politically if they ever become a state. That's why there's no great surge from Puerto Rico to become a state.
What I was going to suggest after the state, if it becomes a state. Okay, no, I think that I understand. Okay, interesting. So when does the Senate vote on this?
If they ever do, I mean, it may just be filibustered or die a quiet death. We'll see. But it's pending before them now. But it tells you where their mindset is. They want to stack the Senate, pack the court, change the rules of the game, seize power. Much of what they're trying to do in the justice system and what they're trying to do in state employment and state universities, they're trying to do by changing the rules of the game itself. I mean, so much so that they are trying to get the courts to set aside the Florida riot laws on the grounds that there's a civil right to riot. Apparently.
Well, okay, so now, okay, before we get there, because I do have my questions on that, having read the lawsuit, I don't know if they rendered any judgment on it. We'll get there in a second. If DC gets statehood, what is to stop House and Senate from discovering the new states of Pennsylvania, South Illinois, Central Valley, etc. Where does the limit? I mean, where does the limit end? What would be the limit in recognizing new states?
I mean, really, it's just the House and other than D.C., it's a unique issue. For every place else, it just requires the House, and if it's new territory, not part of an existing state, then just the House and the Senate and the White House. If it's part of an existing state, you have to get the consent of the existing state. So you could create kind of Northern California, Central. So if they wanted to play games, that may be the next place they go to find Democratic governors that are willing to split up their own state in order to stack the Senate, because they believe they could create 5 Democratic states within one. But they also know they're going to create a problem that's going to create a lot of backlash across the rest of the country. So how much you can sustain that and survive that is an open question.
Okay, and that is the good segue into DeSantis riot bill. Now, I didn't read the riot bill. I read the lawsuit that was filed against DeSantis in anticipation of protests that were coming up that were alleged to be now at risk because of an unconstitutional riot bill. DeSantis's riot bill, and correct me if I'm wrong, I've read the reviews on it, and I've read some of the provisions as alleged in the lawsuit, but basically it wants to create certain affirmative defenses. It wants to enhance certain penalties or sanctions for certain violations. Specifically, I think it wanted to create an affirmative defense if a motorist feels threatened and has to drive through protesters, that will be a valid defense, saving evidence to the contrary. Certain crimes, if committed in the context of a riot, become more serious and more sanctionable. I mean, do you want to give a broader or more specific overview, or is that good enough?
I mean, the simple answer is that they want to discourage, deter, and better disincentivize protest from turning into riots. And the way they want to do so is no more blocking highways, no more blocking pedestrian pathways, no more blocking traffic in general, no more using violence of any kind as part of it, no more assaulting people, no more putting people in fear of assault. All of those tactics, they want to criminalize, they want to enhance this punishments for, create clarity that there's punishments for them, and expand what criminal sanctions are available and what civil remedies are available. And the whole goal is to basically deter these criminal tactics that are converting protest into riots. And in my view, the lawsuit is basically saying we think we have a right to riot. I mean, they put it in different ways, but that's what it boils down to. They don't want to have these limits because a lot of their objection, they're saying, well, there's nothing in here that requires imminent violence. I read the law. Yes, it does. So it can punish you for violent actions afterwards that don't require imminent violence at that point. But again, all of it is they track the law to track the legislation to track Supreme Court precedent, and so and federal analogous law. So they're just realizing that they've got to stop these people from taking over highways, taking over bridges, taking over roads. No mas. It's an automatic felony if you do it.
Okay, now here's the question. One of the provisions that was in the law is that depending on what you're arrested for, you're going to remain in jail until your first bail hearing.
Correct. But that's true always anyway.
Well, that's the thing. Now, reading it, I mean, I don't have any specific expertise on Florida law, but reading it, it does sound like there are already existing laws to deal with all of these things, blocking a highway, encircling a car. There are already defense laws or defenses that exist if you're under threat and you have to resort to exerting physical force. You'll be justified anyhow. You just won't have an affirmative defense, from what I understood, versus having the defense itself. But my initial reflex is, in reading it, on the one hand, there's already a ton of laws that already cover this, if not all of it, save and except for increased penalties for certain types of infractions. And the second thing, keeping people in jail until their first bail hearing, for whenever that can occur. These are issues that we had raised with some of the apparent injustices going on from the January 6th riots, in that they were going with a full sledgehammer, locking people up, keeping them locked away, imposing excessive bail conditions. And it just sounds like one could argue that what DeSantis is doing in Florida is exactly what they were trying to do and did in fact do with the January 6th rioters. And it becomes a question of whether or not it's abusive and excessive, especially since you, in theory, already have laws to govern these very same concerns that you already have.
Well, two things with it. One is all it does is say that you can't catch and release on location. You have to take them in for a bail hearing, because the way that law works, that already is constitutionally conforming. You have to get a bail hearing within 24 to 48 hours under the Constitution. So all that's really doing is saying no more letting them go on location. And there was no giving them tickets, no giving them citations, no giving them summonses. Make sure to jail them through the process. Their main goal there is to break up a riot and get 24, 48 hours of control. So that's all that effectively does. They were calling it cruel and unusual punishment. That's not going to get anywhere, because the right to bail is still protected under 24 to 48 hours, and the law does nothing to change that at all. So and they're not going to win the idea that you shouldn't be arrested on site. And then otherwise, what they really did is they took existing law and just simplified it, streamlined it in one location. So they're basically creating something that's an easy guidepost for judges and for cops to be able to issue the arrest without saying, well, it's this statute over here, or it's this one over here, or it's this one over there. It's saying, okay, it's all right here. If this become a riot, here's all the things that are crimes. Here's all the sentences. Here's how you do it. That's all it's mostly done. That's why, like, when I first looked at the suit, I thought, well, maybe they had a real vague definition. And I was like, no, or a constitutionally dubious one. And it really wasn't that.
But maybe, I mean, I think some of the threshold of the numbers for what qualified as a riot was 3 or more people gathering. I mean,
yeah, but that's not but it's 3 or more that are going to do violence and that are doing violence. So it still requires, and that they have an intent to do so. They have intent to do violence, intent to be disorderly. That's pretty much what most riot laws on the books already are. So, I mean, all they've done is streamlined it. Most of these laws already exist someplace.
Well, so that's one issue, is that if the laws already exist, I'm always concerned in adding new laws when you already have existing laws. It's the exact same argument for, increased gun laws when you already have effectively, all the laws that people complain about not being in place seem to be in place. Let's put more on that. Just, more laws, less justice. I was concerned in the number of what qualifies as a riot, because 3 is a bar fight becomes a riot. And in which case, there's still sanctions for a bar fight. So why do you even need it in the first place? I get increasing the penalties for certain types of infractions, and that is just to say these are aggravating factors, much like hate crime motivation is an aggravating factor for sentencing of what would otherwise be an ordinary crime. So I can get certain parts. It just did seem like it was somewhat overly broad and reduced the number of what would qualifying as a riot, to the point where it's nice that DeSantis wants this now, and everybody, people have faith in DeSantis to apply laws properly, but it might not always be a Republican. I'm just going to forget his word. DeSantis is a governor. I'm blanking, right?
Oh yeah, I mean, all of these things they were already criminalized in some capacity. It's mostly streamlining and specified really to deal with Antifa in particular. So the way in which Antifa, the black bloc tactics, it's targeted them. So they already had laws to deal with this in part, but the problem was they were in different places to try to deal with different things from the past. So that's what they mostly did, is just put it all together in one streamlined location. And so that's it's likely effect. If they had had a riot, it's 3 people together and it was more nebulous, but they said it's 3 people and the 3 people agree on committing violent, disorderly conduct that's defined as criminal in the law. Well, that's basically Brandenburg. So, I mean, that's been established for forever in some capacity. So that's why I thought it was a suit. What was interesting to me was just the filing of the suit suggested, I think it's like Lawyers Matter, some crap like that is the name of the organization.
It was an activist group and a fictional plaintiff, which I didn't understand how you go with a fictional plaintiff, but
yeah. But it showed what some had been skeptical of, which is the belief that there's a deliberate attempt to convert these protests into riots. That's how I read it. It was an attempt to sue, to say, yeah, we're entitled to this. We're going to keep doing it, and you shouldn't be allowed to try to stop it or criminalize it, punish it, or penalize it. And that right now there's enough of a hodgepodge of laws that they can get around in one way, shape, or form, and not having clarity of direction in police. Because, I mean, they've been doing this blocking highways now for years. Yeah. And there's almost never arrests.
But that might just be the political aspect of it, and not the legal aspect. And just Unknown Sailor, and I'm going to remember another chat, was Viva. The bail hearing thing is a direct result of what Portland DA is doing with Antifa, releasing and not charging Antifa rioters caught and arrested. And someone else said, there should have been a provision for Kamala Harris not raising money to bail out people. But what they were doing in Portland, catch and release the same evening. Is that, it's a stupid question, is that already against policy, or is that already illegal, or is that allowed?
There's no law that prohibits that right now in Florida. So, I mean, that right now that's up to the local government. And they're just taking away that power, saying you can't do that, saying you have to arrest them and you have to charge them, and they can't be released until their bail hearing. And if you're going to dismiss the charges, you have to do it at the bail hearing. So it's mostly to buy time. And again, like most of this law is designed to, Antifa creates this problem. What law solves it? And they found a law that may have already solved it, but they put it into one streamlined location. And in some cases, clarified the law where it was ambiguous.
I'm going to read this one because I'm also going to say something. Mike Lindsay says, don't rip on Vaush or anybody. You don't have to agree with them, but don't throw shade. Vaush engages conservatives on a regular basis. No, and I know what people specifically disagree with Vaush on, and having heard some of the clips, I specifically disagree with Vaush on this also. And it goes back to the truth in jest or it's just a joke defense, and some things that Vaush has said as a joke and maybe sometimes not as a joke regarding certain behaviors and certain whatevers.
I've never watched Vaush.
I watched Vaush's debate with Count Dankula as my homework before doing the stream with Count Dank, and I would think that a lot of the arguments being raised by Vaush would not, if they're to hold true of Count Dank, would hold true of Vaush as well. In which case, he might be guilty by his own arguments. But that's a discussion for another day, people. But like I say, anyhow, you disagree with someone, do it civilly. But we're all big boys, and we know what the internet's about. And the internet's about sometimes throwing shade, sometimes throwing the most egregious insults you can think of, just because internet's beautiful sometimes. Okay, so what ended up happening? Did they get a hearing date on that lawsuit? Because it was presentable on an emergency injunctive basis, because they had a protest, I think, scheduled for yesterday. Did a judge hear it, and was there any ruling?
To my knowledge, there's no judicial ruling. So I don't know if they actually held the hearing or not, but I didn't hear about any ruling. Okay,
and neither did I. I was looking, but I am behind an iron curtain here, literally. So Tom Villa says, congrats on 1,000 viewer on Rumble. Amazing how much better you both sound on a free speech channel. That is amazing, because Rumble is doing live streams, and they've set up now individual live stream RTMP thingy things, so everybody gets notifications now for a new live stream, which is great, because it notifies people and they know. The other thing about Rumble is they're going to be enabling some form of financial support, like super chat type thing, and comments sooner than later. So they're up and up, and it's awesome. Now, what was I going to say? Okay, so if anybody knows, by the way, send me an email, david@vivafry.com. That account is full of spam now, by the way, but I do occasionally find gems in there of information. If and when there's a ruling on this, flip it my way so I can see how the judge ruled. But I was trying to follow to see if there was anything for the protest that was scheduled for yesterday. So we'll see. It's interesting. I have my issues with any law that seems to just enhance and clarify existing law, but I understand the rationale. And I mean, I understand the concern, because we've seen what happened. I've seen it from up north, but everybody seems to what happened.
They didn't call it this, but they just should have called it the anti-Antifa law, because that's who it's aimed at.
And I think people did feel that, which is why they got so offended at what DeSantis is trying to do, is that they don't see it as a legal thing, but rather a political thing, or a specific political target. Speaking of specific political targets, good segue into Project Veritas and James O'Keefe personally versus Twitter now. For anybody who doesn't know what has been going on, an overview of the facts. Again, I did a video on it if you want to watch the video if you haven't seen it. Twitter, back in February, banned Project Veritas' official Twitter handle. And the reason why was, I believe that they said that they doxed somebody. It was someone at Facebook, and they posted a picture of him, someone trying to approach him in front of his house. No street, no city, no name, but you saw a number. And Project Veritas tweeted it. Twitter said it violated their terms of service for doxing private information. And I think it was a permanent suspension using the Orwellian newspeak. Then they permanently suspended Project Veritas Action, which is a separate 501c4 entity, because allegedly they accused Project Veritas Action Twitter handle of bypassing a permanent suspension on Project Veritas's account. James O'Keefe's account remained intact until about a week ago. Why did he get banned again? Jeez Louise. That's right. He put out the expose on CNN. And then the same day or very, exquisitely quickly thereafter, saw his personal account permanently suspended with no notification, no nothing, on the basis that, according to a public statement from a SPOX, SPOX means a spokesperson. You learn new things every day. On the basis that he was using multiple fraudulent accounts to artificially enhance or engage conversation, or using accounts to bypass, I think it was something to bypass a ban or to amplify discussion. He then said, I'm suing, and like someone who follows through on his threats, he sued. And the lawsuit alleges all of this pretty much as much, says basically it was obviously a pretextual permanent suspension. There's no way they could have verified. There's no way they could have done this in conjunction with the CNN expose. They ought to have known that he does not operate any fake accounts. He's operated only 3 accounts, his own personal Project Veritas in Action, and that it is defamatory for Twitter's spokesperson to publicly claim that he operates fake accounts. Now, in my video, I did raise what is undoubtedly going to be Twitter's argument that their statement was sort of like not a bifurcated, but it was a double-faceted statement. They said he's being banned for operating fake accounts or effectively for using accounts to artificially amplify discussion, which, depending on which way you go on this, they might say, well, it's less the fake accounts and more the using his personal account to amplify discussion or to bypass bans on his other 2 accounts. We'll see. But the bottom line, he's suing them for defamation on the basis that alleging that he operates fake Twitter handles is defamatory given his profession, given his line of work, and his reputation, which is at the core of his credibility. What do you think of the lawsuit? I like it. I see some issues, but what do you think of it?
Oh, I think it's a very good suit. I mean, Twitter, we discussed this all the way back, even before the Hunter Biden laptop guy filed suit against Twitter, involving Bobby Kennedy, saying that, these bodies that are now taking a different step. It's one thing to suspend or remove someone from a social media platform. It's another thing to go out and just start libeling them and using their existence on your platform as a pretext to libel them. And that's what's happening. And, they started off by going after Bobby Kennedy Jr. on this. Then they accelerated it with the Hunter Biden laptop story. And now they've continued it with Project Veritas and James O'Keefe. And the timing is not coincidental. I mean, it's whenever he is outed, the New York Times or CNN, Twitter has taken hostile action toward him or Project Veritas. It's obvious as the day is long. They filed a suit in state court in Westchester County where they just had a judge say some, very unfavorable things about the New York Times and very favorable things about Project Veritas. They may get the same judge. And I think clearly, Twitter's saying somebody is operating fake accounts and that it's such a bad thing that they have to keep them from even being on Twitter is a defamatory statement if it's untrue. And their point is that Facebook couldn't have even possibly confirmed this statement by the speed with which they made it. In all likelihood, they didn't really meaningfully confirm it. That somebody had just some loose interpretation of this, that they're so accustomed to saying whatever they want without consequence and doing whatever they want without consequence, that they don't understand what it means that when they've gone too far. And they clearly haven't got the lesson. And I think that, just as they will continue to face the suit in the Hunter Biden laptop case of the computer repairman, they'll continue to face the suit. There's another guy who got a $2 million book deal. Isn't that amazing? He and Amy Coney Barrett, same amount. Might make you curious.
Robert, the fact that he got a $2 million book advance and not a sentence, and I say this not to be hyperbolic, the fact that he did not get arrested and convicted and got a $2 million book deal, it's over the top. Now, in my long expose of the lawsuit, I missed 2 big super chats, which I want to pay respect to. Martin says, "Am Florida man. On the second hand, happy to see these laws in today's context, but on the other, there's no way these will be abused. There's no way these will be abused down the road, right? And Cleopatra, I'm sorry I missed it, Cleopatra, says, I know I missed all the important stuff, but I will see it tomorrow. Happy to see over 10,000 people watching. And just to let you know, I really love the Locals Forum and many of the people there. God bless and take care, both of you. Over 10,000, make sure you put a thumbs up so we can get that thumbs up to where it should be. But okay, thank you very much. And sorry I missed those chats. Sorry I could not bring them up in real time. I was talking for too long. But I missed something in what I was saying. The whole idea of the accusation of the fake Twitter handles. They brought out the history of that, and it was enacted by Twitter to respond to the alleged Russian interference and Russian disinformation campaign in the 2016 elections. And so there's something especially egregious about accusing James O'Keefe of operating a fake handle, given the baggage that goes along with this accusation, is that it was enacted so that Twitter could combat disinformation on Twitter. And these, what do they call them? Account farms, or I don't know what they call them, bot farms of these fake Russian accounts that were trying to influence and interfere with American politics. So there's something particularly egregious of the insult. And I love the fact that James O'Keefe is also using some of my videos for some of his Instagram posts, summarizing them. But it's a well-drafted lawsuit. Certainly survives a motion to dismiss. They're going to raise Section 230 or no?
I mean, they may try, but it just doesn't apply to defamation claims. And the lawyers litigating the case are Ron Coleman and Harmeet Dillon, who've had a long history of success, including at the U.S. Supreme Court. So Dillon led a lot of the efforts involving the lockdowns involving churches. I think she had 3 different successes at the U.S. Supreme Court. Ron Coleman is my co-counsel in the lawsuit against Don Lemon, involving his interesting habits. Which you can look up separately. But so Ron's a great lawyer, great guy. He's done some interviews with Good Logic, who has his own YouTube channel he's developing. So shout out to him. But good, smart lawyers brought a good, smart case on behalf of a good, smart plaintiff against an arrogant, condescending defendant. That usually is a good recipe when you have a judge in that particular courtroom who's already expressed some empathy to at least get to the discovery stage. And my guess is it's going to get worse for Twitter. So we'll see what they do. But they made a mistake by escalating against James O'Keefe, in my view. I mean, he'd made clear he was going to litigate. He has more retractions than anybody in the history of journalism that I know of. And people can argue, well, it's a small retraction or a small correction. If they understand the history, most media never issue any retraction or any correction, no matter how wrong they are. And he has over 330 of those. So this is someone who's done a very good job defending his reputation for many, many years. He was subject to very dubious criminal accusations back in the day due to the corrupt New Orleans, Louisiana political machine. Back then, some people had actually asked me to represent him, and had the case gone further, I would have looked into doing so because the case was very dubious. Most of the accusations against him and Project Veritas are utterly false. And I like to see and in full disclosure, I've told his people that I'll be happy to help in whatever case they have or that they're associating with, because they're understanding there need to be this effort to use the legal system to fight back against big media and big tech using their superior power to crush dissident independent voices. And what he just exposed CNN for what everybody knows CNN is. It's big tech coming to their aid again.
And it's just so it's the orgy of evidence. It's like, it's so implausible that James O'Keefe, with the notoriety that his Twitter handles have, however long he had been on Twitter, I don't think I know how long he had been on Twitter, the day after he publishes the hugely embarrassing CNN expose, they discover or allege fake accounts or violating some other terms of service and terminate him. And
in some additional context, they don't go into as much. I think they went into a little bit of it, but probably save it for discovery. Remember, the number one guy to out Twitter was James O'Keefe and Project Veritas, because he got some high-ranking people to say a lot of things on undercover videos about how their manipulation of algorithms, their effort to censor people, their targeting of certain groups for political purposes. Before this became popular news, O'Keefe was the one who outed it. He's the only guy doing independent investigative reporting these days on a meaningful scale. Frankly, I mean, you have Glenn Greenwald, who occasionally is more commentary these days, who's done great work in the past. But right now, the leading, the Upton Sinclair of the modern era is James O'Keefe.
Yeah, I know people's only objection with him is that it's only attacking the leftist institutions or the leftist institutions, but
that's where the power is.
Well, that's
it'd be like criticizing Upton Sinclair for saying, "Man, he only attacked these big corporations." Yeah, that's where the power is. So that he exposes where the power is.
Could this be the case Justice Thomas was begging for? So it certainly looks like. Well, we'll see. They haven't raised the Section 230 defense yet. I just say they're going to, because nothing to lose. If you lose on the motion to dismiss, you proceed anyhow. So you really have no reason not to try to go for 2 kicks at the can. What I mentioned in the video, you mentioned it here briefly, is that this is filed in the same district as the New York Times defamation lawsuit, where they just got, not a massive victory, but they got an amazing victory in that they're allowed to continue suing and proceed to discovery against their in their defamation claim against the New York Times. So same district where he's already had success. I mean, stupid question. Does it any chance it lands on the same judge, or are there way too many?
Yeah, very easily.
Okay.
I mean, there would be certain efficacy and efficiency to having the same judge hear it. So we'll see how it unfolds. I mean, it's just returning the favor to what the government did in a lot of the Roger Stone, Paul Manafort cases, where they made sure the same judge kept getting a criminal case. So, why not have the same judge, the same pretext, the same predicate would be available here. So we'll see what happens. But I think that he's doing a noble work that can have broad-based benefit that maybe will stop big tech from using their platforms to libel people. It's one thing to control what discussion takes place. It's another thing to use the existence of someone on your platform as a pretext to libel them and try to attack their reputation. Section 230 has never protected that, and it's time Twitter and everybody else start to face consequences for it.
I just, they're going to raise the, by the way, O'Keefe Wednesday stream on the list as well. Oh gosh, I mean, we'll make an extra day, we'll make an extra Wednesday in the week when James is ready and available to discuss. Though pending litigation, never a good idea to discuss. But he's a smart dude and he's got good lawyers, so we'll defer to him. But the invitation is out there, and I may start hitting him up more proactively. And I just totally lost my thought. What did you just say, Robert?
But yeah, I think it's a good suit and a good case.
Oh. I remember now. Their argument is going to be, we're not defaming them, we're just enacting and we're just enforcing our terms of service by removing objectionable content, and you can't penalize us for giving us a reason. Otherwise, we're just going to do it with no reason, and then people are going to complain. They're going to say that.
Oh, they can, but it doesn't matter. I mean, in the past, they did just do it and didn't say anything, and that was the smarter, because I'm sure their lawyers told them to do it that way. Once they say something, they're defaming and libeling people. So that's on them. And they know what they're doing. I mean, again, they use Bobby Kennedy as a test case for this. To make, and what happened? That statement gets repeated by media all across the country because it's part of this war to discredit certain people, whether it's Bobby Kennedy on the left or James O'Keefe on the right. It's an effort to discredit those who raise questions about institutional narratives. And that's what they're doing, and they're complicit in it. And they should be held accountable and responsible for it.
Well, it is amazing. Think what you will of James O'Keefe. He's got audacity, courage, intelligence, and it's a well-drafted lawsuit. It's not a flimsy lawsuit. It is really almost as though he waits to get the good evidence and does not jump the gun, because he could have jumped it on Project Veritas's permanent suspension or Project Veritas Action permanent suspension. But it's an interesting thing to bide your time in as much as it drives you crazy while doing it. But but not banking on an error, but it's going to come. Wait for the strongest arguments to come out and then pounce. And he does it, and he's good at it.
He's become self-educated in the law, and he knows how to defend his rights and protect others. And he's doing a very good job of it.
Oh my goodness. Listen to this, Robert. Beavis Wallace says, from McAllen, Texas, was getting sushi and watching Viva Barnes on my phone. Waiter asked, what are Viva and Barnes up to? This is so cool. You know what's cool? I can't go out for dinner. Oh gosh darn it. What is this thing? You go out for food in Texas and you have freedom? Beavis, thank you very much. So I'm all over this lawsuit. It's going to be the saga, the next amazing saga to follow on. The only thing that, from someone who's neurotic and anxious and wants things to happen fast, I'm going to have to wait for these decisions to come out. So we're going to have to follow other sagas in the meantime. And I think we have one. What was the other?
Well, we got two. Three ones left. Big one on vaccine mandates. Another one on the Arizona audit, which was the request of our locals board, and the third one was Daily Mail versus Google. So we could bridge any of the three.
Let's do Daily Mail versus Google quickly. I don't know. I didn't do my homework on this one, so you do this, and then we'll move into the audit, which I know a lot of people want to talk about.
The suits keep accumulating against big tech. So this is the context of big tech manipulating the ad market for publishers. And they're describing also in detail how big tech basically waged war on big media in order to bring big media under its heel, and then big media retaliated, and now they have a sort of collusive agreement going on. But the point of Daily Mail is that the monopolistic manipulation detailed in these state attorney general suits and in the Trump Department of Justice suit it simply lays out the predicate to go after them on the grounds of their manipulation and monopolization of the market in this particular space involving ads for publishers, and how they're effectively controlling what publishers live and which ones die by their manipulation of the market space. So Daily Mail filed a major class action or major suit against Google. It has a very substantial potential monetary remedy, and it's going to be these suits are starting to accumulate from every which direction. Big tech is in serious legal trouble in ways I don't think they have come to terms with.
Well, I liked what you said a couple of streams ago, or maybe the last stream, that big tech now is, the tobacco companies of 2 decades ago. This was touched on in the antitrust lawsuits, where they basically said because of their monopoly, Google is artificially jacking up the prices of advertising on its platform for its own benefit. So it's the mafia increasing the price of its own goods. And now, I think private enterprise is smelling the blood in the water, and people are jumping on it. There's just, in a way, too much to keep up with, because there's only so many lawsuits I can read in a week. So, initial stages of the lawsuit, there have been no motions to dismiss yet, but
just the complaint's been filed. But I think they face something like 100 different class actions from state governments, the U.S. government, and private class action citizens in different courts across the country, which is the most they've ever faced at any time in their history. And a lot of them are very sophisticated actors with very sophisticated lawyers with very strong, well-founded empirical claims and legal claims. So I think they're in trouble. And it's part of why you're seeing motion in Congress, bipartisan motion even, to go at the issue of changing antitrust law to expand its ability to go after these monopolies. Big tech has accumulated too much power. They may regret the day they kicked an American president collectively and collusively off of social media. They started off by doing it to Alex Jones, and then accumulated to the point where they reached the president of the United States, and they're getting blowback across the political and legal space across the country in ways I don't think they're ready or prepared to handle or address.
All right, and it was as J.D. Vance said, in our sidebar from last week, if you can silence the king, you are the king. And yes. I agree. It's getting the pushback that has been long overdue for the needling, proddling, and whatever it is, crippling of a number of things. Free speech on the one hand, and just thinking that you're in a position to make decisions for the general public and literally dictate what they can learn and what they can know.
And what we're seeing is the legal equivalent of J.D. Vance's grandma with a 44 Magnum. And so they're going to see what that looks like being on the other end of that barrel legally.
All right, now we need to do this one. Otherwise, people are going to get angry. The Arizona audit. I know what's going on in the headlines. I see people taking issue with how CNN is reporting on it. We're only talking about the lawsuit now. There is a lawsuit that is it's not a partisan lawsuit coming out of Arizona, is it?
Kind of. So what happened is the Arizona Senate subpoenaed and basically got a court to enforce a audit of everything that took place in Maricopa County in the 2020 election. Democrats filed a suit to stop it, but refused to post the $1.2 million bond the judge required to stop it. And so it's going forward. Now, it reaches some issues, doesn't reach all issues. It is a sad state of affairs that the media and the legal left is scared of a simple audit. These are protocols that have been put in place for decades by the United States Election Assistance Commission, by international election observers, by various blue ribbon election commissions over the past decade plus, recommended by a wide range of scholars, supported substantially by the Carter-Baker bipartisan report of 2005, 2007. And so the whole goal is we should have people have confidence in how the election was done. The way you do so is an audit. This is an audit. Now, it doesn't go as far as I would like it to go. I would like there to be more of a focus on whether signature matches occurred or didn't. My understanding is this audit will not reach that aspect in detail. What it will reach is other discrepancies. It will put to bed one way. This is why if you really believe that there's no problem with the machines, you should welcome this audit.
I was going to say, Robert,
it will put that to bed.
It will reveal potential discrepancies. It might reveal no discrepancies, in which case
correct.
It will further embolden or further confirm that which
fortification that took place.
That yes, it will further confirm the fortification, or it might even undermine the fortification. They didn't even need to fortify, but the whole point.
It tells you a lot that Democrats in the media and the legal left is terrified of the audit. It tells you that down deep, they don't believe their own BS. If they really believed that there won't be any problem with voter registration matches, and there won't be any problem with chain of custody of ballots, and there won't be any problem with the printing and the numbers of the ballots, and there won't be any problem with the machines, why are they so terrified of an audit of that process? An audit, by the way, that's being live streamed and Democratic observers were invited to watch all of it. Apparently, they're not going to do so, but that's their choice. So this is the way an audit should be done. An audit should be done live streamed, videotaped, clear chain of custody of everything, state actors involved, independent observers involved. The whole world can watch and witness it. That's the way it should be done. And we'll find out.
Talk about, we go back to confession through projection. I would imagine their fear is that it's going to be exploited as an opportunity to falsify results, do whatever, knowing that this is the projection that they project onto others. But yeah, look, full transparency to confirm the fortification and the legitimacy thereof, and just to make sure the system works. I mean, there's no problem with that.
And if there's a problem, let's figure out where it is, how it happened, and how you can fix it. So this is why, the media has just done hit piece on hit piece on hit piece on this. It shows how disingenuous and dishonest they are. There's an F word for the election, but it might not be fortification. It might be his fraudulency the second.
It is editorializing the headlines to a degree which is, it would be laughable, except it's par for the course. The media is not about reporting. It's about editorializing and spinning and promoting a narrative at all costs and crushing evidence. And I'm not even talking about election stuff. I'm just talking about Hunter Biden stuff, the CNN stuff, suppressing the evidence and the information that goes against the narrative. Cleopatra says, don't you feel if courts had handled this properly, this would have been done months ago? Too much time has passed. Lord knows what the Dems have done in the meantime. Well, obviously,
and that's where some things are missing, but this is much better than nothing. And I agree. I would love to see it work so it becomes a basis of what we do in the future. And I'll be working with a range of people to create as part of the election integrity project that's been partially put on hold while all these other things happened. But if this works well, we want to use it as an example and incorporate it in legislative remedies going forward. There's no reason why this can't be done on a regular basis. We should build in automatic audit processes that are independently confirmed by independent partisan observers who have an incentive and motivation to raise questions if it exists, so that everybody can have more confidence in our elections. It's a no-brainer to me. I don't care which side of the aisle you're on.
Agreed. Okay, well, we'll see where it goes. What's the timeline on this?
It's ongoing, and it's going to go on for a month.
Okay.
And people can watch it live. So they're like using UV light on ballots and stuff. I think a lot of the Lynn Wood type theories will not find evidentiary support.
People don't even realize it would be good to prove a lot of the often repeated false statements wrong. It would be good for everybody. It would. Anyhow.
Now, I think what they're nervous about is they will find some other anomalies, because one thing that was never explained in Arizona is there's a person who went on TV who said that he didn't vote and his vote was counted as voting. Those anomalies they've never explained. And so things like that, I am curious, how did that happen? Maybe there's some innocent explanation. Maybe there's not. So, but I'm curious. So I think it's a very positive thing. More transparency, always better.
Sunlight is the greatest disinfectant, and I would be always suspicious of anybody who is opposing transparency.
Precisely.
Okay, now let's end it on this one, because this is the one where I just put out a video on this today. It's something that's causing me. It's depressing. The whole story, the Muhammad Anwar death, and the fact that it was committed by two young. The fact that they're girls is not the relevant thing, but 13 and 15-year-old girls who, for whatever is going on in the world, decide to carjack somebody with a taser. And everybody knows the story now. Muhammad Anwar is a 66-year-old Pakistani-born, emigrated to the U.S. for a better life, and this is the fate that he meets in the United States. And when you find out that the assailants, if you've seen the video, you don't see it quite so easily, but they're 13 and 15-year-old girls who are carjacking an individual, crash the car, Muhammad Anwar gets killed, and these two girls were facing serious charges, but now apparently have struck a plea deal where they're going to plead guilty to second-degree murder with a weapon and apparently avoid jail time, but I don't know what sanctions are going to be imposed. So there was a difficult thing. It says, the headline says they're going to avoid jail time, but doesn't say what they're going to experience by way of what's the word I'm looking for? Punishment, for lack of a better word. But I mean, Robert, like under DC law, 13-year-olds can never be tried as adults as a matter of law. 15-year-olds can under certain circumstances, which could have otherwise applied to this crime. Prosecutors said, we're not going to try the 15-year-old as an adult, or we're not going to move to try her as an adult. And they struck this plea deal. Do you know what they're going to get by way of punishment? Or, I mean, they only say no jail time.
I don't. So, I've just seen the headline. So, I mean, I think politically, the disparity of treatment within the District of Columbia between this case and the Capitol Hill case, as it came out that the Capitol Hill rioters did not kill anyone. And it turned out that to be a false story now for months. In fact, I think if people go back, the night of January 6th, we did a live stream, and I think I raised this then. I think I said there's this talk of this guy dying from it, and from other sources, I don't think that's true. I don't think they killed any police officer, and it turned out they've been lying about it for months.
Officer Sicknick, it's Officer Sicknick, New York Times. It's not even lying. It's over the top. They said, publish a piece January 6th. He dreamed of becoming an officer, then a pro-Trump mob killed him. They knew at the very least 2 days later this was not the case, and New York Times still has that article online. But yeah, the disparity just looks terrible. Be in the same district, people getting locked up for selfies based on lies that they had anything to do with, where nobody died, nobody was seriously hurt by the rioters. From the evidence I've seen, there was a cop who, you start compounding it. A law enforcement officer who was the only person who caused death, who shot a woman summary execution style, for which he's faced no consequences at all. Well, his name won't even be publicly disclosed, while they celebrate the sort of legalized lynching of Chauvin, while they are letting these other people walk who commit a real felony murder. That's what a felony murder looks like, what these two people did, while they're locking up grandma for taking selfies in the Capitol. So, I mean, it looks like purely political, partisan, Soviet-style show trials and political theater by our leading law enforcement people. And it's an embarrassment to the country and to the rule of law and the American justice system. Okay, now, but without comparing these two issues, taking Muhammad Anwar's case on its own, and
they should definitely. I mean, I'm not a fan of our incarceration system, but the norm would be at least 5 to 10 years in prison of some type, whether it's a juvenile facility or other facility of some means under these circumstances. So, I mean, and then we had the U.S. Supreme Court rule this week that you can treat juveniles as adults for certain kinds of murders in the Mississippi case. So, and that's how it's commonly done. So I would say, here's what I can't if these people's politics were different or the racial dynamics were different, can I honestly tell people they wouldn't be treated much more harshly? And I can't, and that's a problem.
Well, so, and the only remotely similar case that I could think of was, I don't remember the guy's name, but I think he was a 20-year-old, give or take, 19 to 24-year-old guy. He was drag racing with his buddy, 100 miles an hour, crashed the car, killed a mother and her child. He got sentenced to 24 years. Now, fact pattern is much different. It's always different. The only question
is... Well, this fact pattern is worse, frankly. I mean, they set out to commit a crime that they knew could have this effect. So,
Here's my issue, Robert. It's not a question of not taking it seriously. It's terrible. The only question is, once you get into these tragedies, and I say tragedy, yes, they're 13-year-old kids go out and thinking carjacking is like, a consequence-free type thing. We're just going to go steal a car and it'll be a fun story to tell our friends the next day. And then this happens. And people are saying, lock them up, treat them as adults. What is the age at which you would not, what is the age at which age would be a factor if 13 is not that age? I mean, would it be 10? Would it be 9? Would it be, at what point? And at what point also do you look at the situation and say, if the judicial system is supposed to have any rehabilitative function, is this not the case for it? Or do you just abandon, say we're going to just punish these kids, make an example of them, and think that that's somehow going to change anything, and think that that's somehow going to attenuate or alleviate or do justice in a situation where you can't possibly have justice? I mean, I'm just taken aback by the ages of the kids, and it does cause the question, like, what
usually when your hardcore criminals start, is around that age, the age of what has historically been considered adulthood. So 12, 13. That's when your hardcore criminals start. So the that part doesn't kind of shock me, to be honest with you.
And people
and these are people that are on a criminal path. Now, again, I don't think our prison system functions as an effective means of deterring future crime, other than keeping those individuals from doing so during the time period they're incarcerated. I think our system has major flaws in it. And so I'm sympathetic with that criticism of the justice system, but I'm not seeing them find an accommodation for that. I'm seeing political disparities because of the politics and race involved led to different treatment in by DC. That's what I think is, I don't think they're sincerely concerned with problems of juvenile over incarceration necessarily.
Well, that's the issue. I mean, people are asking, did they have a criminal history or were they members of a gang? They haven't identified the kids, so you don't know any of these things, which could really change the situation. Was this just anomaly of behavior for kids who had no history, or was this, were they already up to no good in other respects? I just think, I gave the anecdote of when I was a kid. You just don't think these things through. You don't even think about the potential consequences. You just behave like idiots when you're a kid. And Robert, the example I gave, it was not to say that they're similar at all, but remember there was also that story of the girl who was driving while intoxicated, crashed the car and killed her niece or her sister, I forget which. And she was live streaming it on social media. But for the grace of God, people make terrible decisions, which, can go one way or can go the other. Could have been an absolute non-incident. The kids could have taken the car and crashed themselves and, not have it end up the way that it did. But you're dealing with kids with a non-fully developed brain who just do stupid things because they don't think past the tip of their nose. And then the question is, what is the function of the criminal justice system? But when you hear that there's no jail time, the question I do ask, what is going to be their sanction? Are they going to be in juvie? Are they going to be going for psychological rehab, reassessment, whatever? Not knowing what's going to happen or if it's going to even take. But the youngness of the perpetrators in this is something that does, it does bring back certain memories of decisions I made, which, but for the grace of God, could have ended up totally differently, where someone would be looking at me like saying, how could you have taken your car joyriding and killed your brother type thing? And it's a different circumstance. Yeah, nobody set out to go carjacking in my anecdotal case, but you do stupid things without even thinking of the consequences because you're a kid and you don't think like that.
Well, I think that degree of analysis as to whether or not these are kids who got in over their head or just young criminals starting out, there wasn't enough time for that to happen by the time of this plea deal between the time of the crime and the plea. So that tells me that wasn't their motivation. Politics and race was their motivation. And that's what I find problematic.
All right. Do we wind this up now? Because Matt Christensen is going live now, and I should invite everyone to go check out Matt because I should be making a cameo somewhere around 9:30 tonight. Also talking about
one more topic. I will be filing suit on some of these vaccine mandates that they're imposing on employers and educational institutions, because this is a COVID vaccine is unique. It's an emergency use authorization vaccine. So it's under 21 USC 360 BBB. We always have to have laws like that. When we have laws that have like BBB after them, maybe we have too many laws, but the law says that if you have an emergency use authorized medicine of any kind, by the way, theoretically, that's supposed to be premised on like biological warfare. It's kind of it's a future hush hush maybe about the nature of how that may combine with Wuhan. But basically the law says you can't compel it. You have to have informed consent. And under that law, now this statute's never been interpreted in the history of federal courts, which is interesting. But it appears to clearly give a right to in an emergency use authorization vaccine, which is what all the COVID vaccines are, to the Nuremberg Code, which, by the way, the Nuremberg Code has been adopted as international law enforceable in the United States by multiple U.S. federal courts, including actually a MK Ultra tinged case. Which will be another thing down the road.
Which has ties to MK Ultra does have ties to Montreal, right? I think it has ties.
Oh yes. Okay. Several of the key actors are up in Canada, so you got to watch out for those Canadians. But because of that, between the Nuremberg Code requires informed consent, this statute which requires it for any emergency use authorized vaccine, between the two, I believe there's grounds to sue, as well as on grounds of where there's discrimination based on disability or religion. And I think every employer requiring this, or every educational institution requiring this without exception, is violating the ADA. I think between those, we have good grounds to sue. And when I draft the suit, I'll have a copy of it available on our locals board so that people can use it and copy it if they're dealing with the same problem with their employer or educational institution.
I mean, that's going to be phenomenally interesting to see. That will be similar to, well, I guess that's not similar to the lawsuit of the federal employee who may have been sanctioned for not taking the vaccine, but along the same lines.
Yes, and it will also have the constitutional provisions as well. It's a violation of bodily integrity and the right to privacy.
Okay, amazing. What else, Robert, before we finish up?
I think we hit them all.
I think we definitely cover them all. I think it is amazing. The most jam-packed 2 hours of legal knowledge and current events you'll get anywhere.
I'll be over at the live chat. You can find it at right there, vivabarneslaw.locals.com. And you just go to the pinned tweets and you'll find a pinned one, or not pinned tweets, pinned comments. You'll find a pinned one that has live chat. You click on that, and I'll be in the live chat in a few minutes for about half an hour or so.
All right, excellent. So everybody, with that said, thank you all for tuning in. We're hitting 10,000 a week, and it's fantastic. And the comments are great. The discussion is great, and even the even some of the jabbing in the chat is still good and good natured. So thank you all for tuning in. Rex, you know what, Robert? Leave us with something good, and then we'll say our proper goodbyes afterwards.
Well, watching all the righteous lawsuits by James O'Keefe taking down everybody from the New York Times to Twitter is a beautiful thing to see, and it's a sign that our legal system can yet work for the purposes and aims of justice and constitutional freedom in our country.
Awesome. And with that, everyone, enjoy what's left of the weekend, and we will see you next week.